Hello, and thank you for joining us for the first session of our in-house Counsel CLE webinar series, Grow, Protect, Operate, and Finance. Before we get started, I have a few housekeeping notes. For the benefit of all participants, attendee lines have been muted. Should you have any questions that you would like to submit during the event, you may submit them through the chat box at the bottom of your screen. If we cannot address your question during today's webinar, we will follow up after the program. Please note that today's webinar will be recorded and circulated to all registrants via email after the event. Should you have follow-up questions at that time, please reach out to any of the key contacts listed in the email communication. Please note that Dentons can only issue CLE credit for attendance during the live broadcast of the webinar. The following is a very important message regarding CLE credit. The webinar window must remain open for the entirety of the program, and it must be the only window on the forefront of your screen. WebEx will detect if you minimize the program or use the computer outside the webinar software, and this will prevent your earning CLE credit. One other important note, if you have a New York, New Jersey, Pennsylvania, or Kansas license, please be sure to listen for the code word that will be given during each presentation. When prompted, you will need to enter the code word into the Q&A section of the screen. If you don't have a license in these states, you can disregard that message. And now I'll turn it over to our first presenters, Jordan and Craig.
The first part of this presentation relates to the protect aspect of the webinar series, specifically with respect to consumer-facing type business and marketing and laws that exist around that area. My name is Jordan Cameron. I'm an attorney with Dentons in the Utah Silicon Slopes office. And with me is Craig Kleinman, Deputy General Counsel of Purple Innovation, which is better known as the Purple Mattress Company. Craig and I have a working relationship where we address these issues on a frequent basis, and we're excited to be here to present to you and hopefully answer some questions that would be helpful. Our presentation is a high-level overview, specifically focused on consumer-type claims and consumer-facing business. So when I say consumer-related claims, we're not limiting this to claims that are exclusively brought by consumers. Of course, the FTC and attorneys general have authority to pursue consumer-related claims, sometimes in place of the consumer. So we think more broadly than simply consumer actions or consumer private actions, and focus on a more broad scope, in particular FTC. In true FTC fashion, the presentation starts out with a disclaimer, and in true consumer fashion, we're going to go ahead and skip that. Also in the slides, you'll find a summary that we don't really need to address right now. We'll just jump right in, given length of the presentation and the time limitations that we have. We'll start out first with a high-level overview of FTC Truth in Advertising, or the Ftc Act, which is found in 15 U.S.C. 45. Generally, the Act addresses unfair methods of competition that affect commerce and speaks specifically to unfair or deceptive acts or practices. The Act itself doesn't expound on that. It simply dictates that unfair methods of competition or deceptive or unfair practices are declared unlawful. The way that these laws come to being and the specific regulations that apply come about in a variety of ways under the rulemaking authority vested with the Commission, which allows the Commission to direct various methods of compliance and identify certain practices that constitute unfair or deceptive acts affecting commerce. Ultimately, though, the main question at issue always in terms of truth in advertising is whether or not the advertising has a tendency or capacity to be false or deceptive. So in this illustration, I think this is an experience that we've all likely had. And it's reminiscent of what were the so-called hamburger wars in the 80s and 90s, where the fast food chains were engaging in disparaging competitive advertising in an attempt to gobble up market share for their fast food hamburger products. What arose out of that were FTC opinions, case decisions that give a lot of guidance and clarity into the types of advertising that companies can engage in, and really help to flesh out the false, unfair, or deceptive restrictions within the Ftc Act itself. As a general understanding, there are a number of claims the Ftc Act pertains to based off of the different opinions and the different statements of compliance. And each of these are claims that require a unique or a different kind of case-by-case analysis in determining whether or not such claims become misleading, unfair, false, or otherwise deceptive. And we're not going to go into tremendous detail on these individual types of claims. We're just kind of setting them out here for you to have a general understanding of the different areas of claims that exist. So the first being called monadic claims. Monadic claims are claims that tout the benefits of the product itself. So benefits of a product based off its own attributes without any comparison to other products. Product A is good for X, Y, Z. For example, this arthritis cream is good for a topical application to treat arthritis pain. Of course, part and parcel of that are comparison claims. Comparison claims are claims that compare an advertiser's product to the other party. Paper towels. Certain companies' paper towels absorb more than a competitor's paper towel. And you've all seen those commercials where you see the demonstration of the robust paper towel sopping up and absorbing a large spill, and then the competitor's paper towel being used on a similar size spill and it falling apart or sogging and disseminating under the liquid without any sort of effect or positive effect. Obviously, in those types of comparison claims, which we'll speak about in brief terms, demonstrations need to be accurate. They need to be real-world type demonstrations to show the actual effect and abilities of the product instead of a dramatization. Of course, a dramatization, emphasizing the good or emphasizing the bad, could have an effect of being unfair, could have an effect of being deceptive. Another area is third-party claims. These are any advertising message that consumers are likely to believe reflect the opinions, beliefs, findings, or experiences of a party other than the sponsoring advertiser. This has become really popular now with influencer-type marketing. Obviously, social media is full of influencers and people trying to be influencers, oftentimes touting their own experiences and benefits of using a product. These fall into the category of third-party claims. Traditional endorsements, or celebrity endorsements, can also fall into the category of third-party claims. So typically, in a celebrity endorsement, those are not understood to be real use scenarios, so much as paid advertising. And the statements of compliance on that from the FTC go into much detail about that, and how to distinguish between those types of third-party claims, what's appropriate and what's not. And then finally, there are establishment claims, which are claims proved by competent and reliable testing. An example of that is clinically proven to accomplish some specific goal. The claims specifically have to have, and we'll go into this in more detail, but have to have this type of substantiation claimed in the actual claim itself. So if something claims that it's clinically proven as an establishment claim, then then it must have that type, a specific type of substantiation. In order to assist with your review and understanding of this in more depth, We've included in the materials a number of exhibits, and those exhibits are, for the most part, a compilation of policy statements by the FTC. For example, Exhibit 1 is the Deception Policy Statement, Exhibit 2 is the Unfairness Policy Statement. There's a Substantiation Policy Statement, so on and so forth. And there are 12 exhibits that we presented at the end of the materials that you can rely on. Those will go into a lot more detail. We've compiled those in one place to make it easier for you to find what you're looking for. Obviously, we're not going to have the time today to go into a tremendous amount of detail on all of those, so we're going to focus on a high-level application of the standards across the board. So let's start with the reasonable consumer. The reasonable consumer is defined as the typical person looking at the ad. In analyzing an advertisement's effect of or possibility of being deceptive or misleading or unfair, the analysis considers all possible meanings that can be gleaned from the ad, whether expressed or implied. To state from an opinion, FTC versus Sterling Drug, 317 F. 2nd, 669, the Commission examines the entire mosaic rather than each tile separately. A reasonable consumer standard is applied to determine deception and unfairness. So oftentimes in dealing with marketing, specifically marketing departments for clients, the argument becomes, well, we're not exactly saying X, instead we're saying it as Y. And of course, sometimes the cleverness in advertising is what drives consumer participation. However, sometimes that cleverness can cause problems where what we're intending to say or what we think we're saying could be construed as something different or something broader than what we're actually saying. So we can't lose focus on the entire mosaic in looking at a specific tile in terms of what our advertising claims are. An advertisement or marketing practice is deceptive if there's a representation, omission of information, or some other practice that is likely to mislead a reasonable consumer, and which is likely to influence or otherwise affect the consumer's conduct or decision with regard to a product or service to that customer's detriment. So in the slide, there's a kind of comical example that I think is largely presented in jest, though it very well could be a true experience of an embroidered rug that somebody bought, presumably off of Amazon, that merely identified the measurements as a 4x6, and of course what the consumer got was a mouse pad, 4 inches by 6 inches. In the tweet that accompanied the post, says, bought a rug online for my room and realized the importance of specifying the size of the product you're selling. So this is an example. Failure perhaps on the advertiser side to present in honest terms the product that they were selling, but also could be a failure of the consumer to actually take into account the information that was being provided in making a purchasing decision. Of course, if it were determined that a reasonable consumer would not see the indicating information that this was in fact a mouse pad and not a rug, then there could potentially be some liability for the advertiser in that context. In a nutshell, the deceptive statement or statement of deception by the FTC simply indicates that advertising must be truthful and non-deceptive, that advertisers must have evidence to back up their claims, and that advertisements cannot be unfair. It's important to note that a claim can be literally true, but if it is only true in limited circumstances, or if it is subject to more than one interpretation, one of which is not true or might be misleading, and its overall effect, it may be deceptive. Again, it's important not to look at claims in isolation, but rather to consider their overall effect. So at this point, let's move on to just notes on disclosure. There's some important information that has come out of various opinions regarding disclosures and the effectiveness of that, the ability to rely on disclosures in presenting product advertising. And some highlights from that are simply that accurate information in a footnote or text will likely not remedy a false headline because consumers may only glance at the headline. So, you know, it's important to understand that as an advertiser, we can't just say whatever we want and then drop an asterisk to the bottom of a web page providing clarifying information, especially if that information contradicts or could somehow be inconsistent with any of the claims identified in the more prominent portion of a website or other advertising media. Similarly, disclosures have to be clear and conspicuous. Clear and conspicuous is defined as readable or audible and understandable to a reasonable consumer. Let's talk more about that. We have what are called the 4 Ps. This comes from Volkswagen of America FTC case 125 FTC 74 that identifies 4 factors in determining whether a disclosure is adequate. It looks at prominence, presentation, placement, and proximity. Regarding prominence, that element speaks to whether qualifying information is prominent enough for consumers to notice and read it or hear it, depending on the way that it's presented. Presentation is whether the information is presented in an easy to understand language that does not contradict other things said in the ad and is presented at a time when the consumer's attention is not distracted. So, for example, on a commercial, there may be some action-packed depiction of some superstar drinking an energy soda or something and then engaging in some crazy acrobatics over an explosion that could be distracting and eye-catching, and it likely would not be appropriate at that time in the ad to, in the bottom of the advertisement, present in some sort of small text a disclaimer regarding the effectiveness of that product. Of course, puffery is an exception, and if you're engaging in clear puffery, then it's likely not to be construed as misleading, but there is a fine line there. Placement indicates or speaks to the location of the material information. It needs to be located in a place and conveyed in a format that the consumers will read. So this begs the question of whether, for example, in a website application, a disclaimer that's included in terms and conditions that you can only access by clicking a button to a link is sufficient prior to checkout, or if those material terms and material disclaimers need to be presented in some other way before checkout. And then proximity speaks to the location, that the disclaimer needs to be located in close proximity to the claim being qualified. Again, in the example of terms and conditions, burying material qualifications and terms behind a hyperlink might not be sufficient. Moving away from deception now, let's look at unfairness just briefly. The principal focus of the Commission's unfairness policy is to protect consumer sovereignty by attacking practices that impede consumers' ability to make informed choices. For more explanation on this, take a look at International Harvester 104 FTC 949. It states that unfairness on the basis of International Harvester's failure to disclose that the potential risk of explosion from fuel geysering on its tractors. So this is a little bit different in terms of, or different from deception in the sense that if there's a known risk associated with the product, that may give rise to a duty to disclose the risk to the consumer, and a failure to do so, though not deceptive in a sense of misleading the consumer as to the nature or purpose of the product, it would be unfair in the sense that it does not provide the consumer with sufficient detail to make an informed decision. thereby impeding the sovereignty of the consumer in that regard. There are three elements that have been developed with respect to unfairness. Specifically, whether the act or practice causes or is likely to cause substantial injury to the consumer, whether the injury is not reasonably avoidable by the consumer, and whether the injury is not outweighed by countervailing benefits to the consumer or to competition. So regarding element one, this is an objective test that looks to economic harm or a threat to health or safety. Element two is more of a subjective standard, specifically speaks to whether the seller behavior unreasonably creates or takes advantage of an obstacle to the free exercise of a consumer's decision-making. Now, the law and opinions on this dictate that the factor is not intended to be applied in a paternalistic way, simply stating that if a consumer could have made a different choice but did not, the commission should respect that choice. And then element three considers both the cost of imposing a remedy, such as the cost of making a disclosure, versus any benefit that the consumers would gain from such a disclosure. So looking back to the International Harvester decision again, the analysis would look at what is the cost for International Harvester to disclose to consumers that there's a fuel geysering risk, even though it's a very low risk. And, compare that against the benefit the consumer would enjoy. Ultimately, the determination would be that the cost to disclose is very low, but the consumer benefit in knowing that information would be high. Moving away from unfairness now, and I recognize we're moving somewhat quickly. Like I said, there's a lot to cover here. We've provided more substantial materials for you to kind of dig in on your own, self-study a little bit deeper, but I wanted to just give a high level for purposes of this presentation. And moving now to substantiation, which I think is a really important piece of the overall puzzle. Again, looking at establishment claims that must be proved, we have to understand a clear understanding of substantiation duties. And this is an area where, in my experience, marketers often get very confused or tripped up. And we're going to have Craig speak to this in just a minute based off of his own experience internally with Purple and dealing with marketing. Simply, substantiation is the rule that you must have evidence to support or back up whatever claim you're making. So in the simplest terms, an advertiser must possess at least a level of substantiation expressly or impliedly claimed in the ad. So if something says it's clinically tested, then there must actually be clinical tests pertaining to whatever that claim is. If something says it's doctor approved, for example, there must be some basis upon which you can claim that this is doctor approved. Whether that's a survey of doctors across various locales and their own experience in prescribing or utilizing whatever the thing is, that may be enough. There may be some other method to develop substantiation for that. But then it begs the question of what about other types of claims? Mom's favorite coffee, for example. Is that mere puffery? Does that have some sort of basis that would require independent substantiation? These are the questions that we need to ask, and they can really only be answered on a case-by-case basis. So, for example, mom's favorite coffee may just be ad language. It may be puffery. It may be a clever brand name, nothing more. Mom's favorite cough syrup may imply a different type of standard. It may indicate that mothers were actually surveyed to determine which cough syrup they prefer to give their children, and they feel most comfortable giving to their children. So case-by-case analysis is very important. For more information on this, you can look at Honeywell 126 FTC 202. If no specific level of substantiation is claimed, then we look at what are called the FISR factors. FISR factors analyzes the type of claim, the benefits if the claim is true, the consequences if the claim is false, the ease and cost of developing substantiation for the claim, type of product, and the level of substantiation experts in the field would agree is reasonable. I think number 6 is maybe the most difficult. Oftentimes we sit around tables with marketing teams trying to determine what level of substantiation do we need for product X. And the reality is that if it's a group of attorneys and marketers in a room, we likely don't know what level of substantiation experts in the field would agree would be reasonable, which is why it's always important to have consulting experts in whatever field, whatever industry the product pertains to help advise on substantiation in order to satisfy the FISR factors in that analysis. FISR's citation is 81 Ftc 23. Craig, do you want to speak to this for a minute? You've been in a lot of these roundtable discussions about substantiation. What have you found are good strategies as in-house counsel to address FISR factors or just the approach to substantiation?
Sure. I think it's helpful to have groups involved early on, talking across functions in the company. For example, you have your product development team, and they've got this great idea, and you've got a marketing team that wants to sell it and say certain things about this product. And then we also have like testing teams that can test products to make sure it'll do what we think it's going to do. And sometimes we'll all get around together. Sometimes we'll bring our outside counsel in and just make sure that the marketing says, I want to say X, is that possible? The testing team says, well, yeah, we've tested X, Y, and Z. These things will work. And outside counsel can review and say that these claims look good. That would pass enough because you have these tests in place and they make sense. So I think it's important if you can do it early on. If you're coming into it retroactively, you may have to get tests later in the process to substantiate. But just making sure, I think the bottom line is making sure the marketing team knows that certain claims require substantiation and that you need to get testing to make sure that if you want to make certain claims, you have to have some levels of substantiation.
And I think one important piece of that, Craig, too, is just the testing people, right? I mean, let's not forget them. The product innovators, the scientists, the ones who have that foundational knowledge. And honestly, with a lot of types of claims, there are established standards that you can refer to. And industry people in the field will typically know what those are. So like Craig is saying, it's very important to get all the pieces together early on instead of trying to retroactively back into substantiation, which can be much more costly and sometimes insufficient or frankly too late. So let's look specifically, and thank you for that, Craig, for that insight. Let's look at health and safety claims real quick. So the health and safety claims require competent and reliable scientific evidence. So this is, of course, different from survey type evidence, which may satisfy claims that don't pertain to health and safety, performance claims of a more innocuous nature, for example. But with health and safety claims, the standard really is competent, reliable scientific evidence, which are typically defined as tests, analysis, research studies, or other evidence based upon the expertise of professionals in the relevant area that has been conducted and evaluated in an objective manner by persons qualified to do so using procedures generally accepted in the profession to yield accurate and reliable results. Now, this is a little bit of a mouthful. Ultimately, though, the question becomes whether there's a scientific basis that's credible to support the claims that you're making. And in this particular context, consumer satisfaction surveys and studies demonstrating placebo effect are insufficient. Those do not rise to the level of competent, reliable scientific standard. Similarly, anecdotal substantiation is not enough. It's insufficient to say all of our customers claim that their pain was relieved, or 90% of our customers claim their pain was relieved by using this cream. That is not competent, reliable evidence. It's anecdotal. It's not a sufficient basis for substantiation. Whether or not this requires clinical testing is a question that's yet to be determined. So I think the takeaway from this is, can we develop reasonable scientific evidence outside of clinical testing? In some applications, yes. Again, this is a case-by-case analysis. For more information, take a look at American Home Products 98 FTC 156. Really quickly, we'll talk about influencers and endorsers. Simply, others cannot say what the company cannot substantiate. So you can't put people out there on Instagram claiming from their own experience that they had some positive benefit, specifically a health benefit, or particularly a health benefit, where the company doesn't have substantiation to back that up. I keep using the analysis of analogy of a cream. If a company advertises an arthritis cream, they have no scientific basis whatsoever to claim that it actually reduces arthritis pain, and then they have influencers out there saying, yeah, I use this, and all my arthritis pain in my fingers and joints went away. That would be improper. Specialty claims require additional types of review and substantiation, and typically have specific FTC policy statements. If you can't find any FTC policy statement that applies to specialty type claim, then look to commission decisions, opinion letters, and case law. So examples of special type claims would include made in USA, for example, biodegradable, hypoallergenic, free trade, recycled materials, environmentally safe, organic, so so-called green claims would all fall into this category and do have FTC policy statements that correspond to them that provide a lot of guidance. I'm going to use Made in USA as an example of a standard that is developed from policy statements, commission opinions, and case law, ultimately to arrive at a substantial transformation test. As for a product to claim that it had been made in the USA, it must undergo substantial transformation. Now, what substantial transformation means depended on a variety of different factors to consider. For example, whether the key raw material is foreign or domestic, the percentage of foreign content, if any, in the product, how far removed foreign materials are from the finished product, percentage of cost of the product manufactured in the USA versus foreign, and then, of course, whether the claims are qualified in some way. It's a lot different to say made in the USA than to say made in USA of domestic and foreign materials. Regarding element 2 specifically, any percentage of foreign content must be low, but there is no fixed point for all products where it suddenly becomes all or virtually all made in the United States. And of course, all or virtually all being set off in quotations as the actual case language. Ultimately, the analysis must arrive at the conclusion that the result is a new and different article of commerce with a name, character, and use distinct from the articles from which it was transformed. Assembling a bunch of foreign parts into a flashlight is not substantial transformation. Importing raw material that undergoes a chemical transformation, thereby becoming a completely different product or compound, would likely be substantial transformation. Ultimately, one of the things that we look at in this analysis is, after the final product has been created, can we still separate out the parts? Can the parts still be used for their original intended purpose? And if they can, likely that there was no substantial transformation. Let's move on to enforcement liabilities and penalties under the FTC Act. A couple of high-level things to note. There's strict liability under the FTC Act for false or unsubstantiated claims. The advertiser is strictly liable, and neither proof of intent to convey the deceptive claim nor evidence that the consumers have actually been misled is required for a finding of liability for a false or unsubstantiated claim. There's also individual liability for false or unsubstantiated claims that can apply to corporate officers or control persons. And this arises if the officer owned, dominated, or managed a company, and if naming the officer individually is necessary for the order to be fully effective in presenting or preventing the deceptive practices in the future. It's been determined that individual liability is justified where an executive officer of the company is found to have personally participated in or controlled the challenging acts or practices, or if the officer held a control position over employees who committed illegal acts. So if you have a CEO who, recognizing the risk and recognizing a lack of substantiation, compels the company to move forward making false claims or unsubstantiated claims, then it's very likely that the FTC could seek and likely obtain some sort of damage or relief against the individual control person. So let's talk about consumers and competitors briefly. There's no private right of action under the Ftc Act, but let's look at the Lanham Act, Section 43, which is in 15 U.S.C. 1125, which states that any person who, on or in connection with any good or services or any container for goods, uses in commerce any word, term, name, symbol, or device, or any combination thereof, or any false designation of origin, false or misleading description of fact, or false or misleading representation of fact, which is likely to cause confusion or to cause mistake or to deceive in commercial advertising or promotion, shall be liable in a civil action by any person who believes that he or she is likely to be damaged by such act. So the Lanham Act does create a private right of action under a standard that's very similar to the FTC standard. However, case law cautions against conflating the FTC regulations with false or deception and burdens of proof and damages that would need to be proved under a Lanham Act claim. So all this to say that while there's no private right of action under the FTC Act specifically, individuals could potentially move, and certainly competitors could move if they believe they have a cognizable claim for which damages could be established for any sort of false or deceptive practice. Under the Lanham Act, damages include defendant's profits, the disgorgement, any damages sustained by the plaintiff, and the cost of the action, and in certain exceptional cases, possibly attorney's fees. The FTC, of course, has authority to enforce the FTC Act. That authority comes from 15 U.S.C. 45, and the types of remedies the FTC can seek are very broad. First and foremost, injunctions. The basic administrative remedy is a cease and desist order, which is to enjoin the conduct alleged of the complaint and prevent future violations. However, notably, the voluntary cessation of an advertising campaign is not a defense to a Section 5 or an FTC Act action. Fencing in is another remedy the FTC can seek, essentially just putting barriers around a company in order to further quell a little bit the future practices that are found to be violative of the FTC Act. Let me look at a comment here. Let's see, okay, not relevant to me. Corrective advertising, disclosures, notifications, the FTC can require businesses from making corrective advertising. There can be bans, so individuals and also businesses can be banned from engaging in certain businesses or certain actions This is very common in telemarketing, where it's been found that companies violated the Tcpa or the telemarketing sales rule, which we'll talk about in a minute. And actually, FTC has authority over TSR, which would essentially ban repeat offenders for life from engaging in telemarketing or selling any type of business opportunities or things of that nature. So bans can be specifically tailored to the practice. Let the punishment meet the crime, so to speak. Name excision, an example of this is a company that was called ABS Tech Sciences. They were enjoined from using further use of the term ABS as part of a trademark or trade name because it was determined that consumers would likely confuse its product with factory-installed anti-lock braking systems, which is not the case. And of course, financial remedies, disgorgement, restitution, sanctions can be up to $43,793 per violation under 16 CFR section 1.98. And just an example of this in application, a particular weight loss claim, a company was ordered to pay $10 million in redress from the marketer purporting to advertise weight loss products without substantiation. So damages can get pretty significant for violations of the FTC Act. Attorney General may proceed in a civil action against violators of a commission order and may seek damages of not more than $10,000 per violation at that point. Okay, so very simply, how do we protect? Of course, the important piece of this is to know the law, to know how the law applies to your business practices. It's also important to know the process. What I mean by this is, how does an FTC action come to be? An example of this was a client that I had several years ago. It was in the cosmetics industry, received a complaint from the FTC that was served via mail. And the attorney that was representing it at the time did not understand that the FTC can serve a complaint via mail, and instead defaulted to the traditional rules of civil procedure and told the client, you don't need to respond to that because it wasn't served. Well, they didn't respond, and default order was entered, and we later came in to kind of clean up that mess. Of course, the FTC can serve by mail. So it's important to know the process. It's very important to have written marketing policies, but obviously, if you don't enforce those policies, they're not as good as the paper that they're written on. Contracts, indemnity with affiliate marketers and others, a substantiation file that marketers can access to understand the nature and scope of substantiation. One thing that I've found really helpful is a dynamic approved claims list. So as marketing presents claims that get approved by legal, that there's a document internally that identifies what claims have already been approved, and that helps to streamline the marketing process. And then, of course, communication between legal and marketing is very important. Well, let's turn the time over to Craig now. He's going to talk about dealing with counsel's recommendations in the real world. Obviously, the conflict that exists between outside counsel and internal marketers list who have their must-have list, which oftentimes corresponds almost directly with outside counsel's can't-do list. And Craig, being caught in the middle of that, is going to talk for a bit about the best way, kind of best practices to handle that in the real world.
Thanks, Jordan. So I've been at Purple for about 5 years, and one of my responsibilities is to coordinate legal review for marketing. And one of the first things I did when I got to Purple was I got to know the marketing team. Was frequently in their area. I would go to some of their team meetings. We'd have lunch together, and we became friends. So it was natural for us to just talk about what they're working on. I asked a lot of questions when I got there. I didn't fully understand how the company advertised and things on Google, things on Facebook, and different social media platforms. So it was important to really understand where our advertising was going and what we were trying to accomplish. And like Jordan said, there's frequently a tension between what the marketing team wants to say and legal saying you can't say that because X, Y, or Z. And so I kind of look at my role as being that bridge, trying to figure out a way to get the marketing claims that we want to say, but do it in a way that's compliant. I've always had the mantra that I'm not going to be Dr. No. I want to find solutions. And so I work with the team. And sometimes it means like we just sit down, maybe today it's on a Zoom call before we're in a conference room, but we'll pull people in from the testing team, and we'll bring Jordan in as our outside counsel and our marketing people and say, well, we want to say this, and this is where the tests are. And so we kind of like find a hybrid solution to making the claims that they want to say. Or we say, let's focus on something else that is great about our product. Let's say that for now until we can build that substantiation portfolio to where it's where we want to have it. The other thing that we try to do is we have a regular training, have Jordan come in, and he does an annual training with our marketing team to go over the nuances of the laws, and we have a large or long Q&A hour where people can ask all their questions, and that really helps to flesh out what people are working on. I've also found that in marketing, a lot of the entry-level positions have a high turnover, so there's always new people that need to be trained. When I find someone new, I will usually try and schedule some time to like spend maybe half hour and just go over some of our history, some of the reasons why we need substantiation, kind of explaining the risks that are out there for us. And it's always helpful for them to know why we're asking them to do certain things. We have a list of policies that are for our marketing team. We keep that updated. We also have that dynamic approved list of claims. That's super helpful, especially when there's someone new. I'll send them the link, and it's like, oh, their whole world opens up. Oh, I have all these things I can say. These have already been vetted and approved. These are the things we need to work on substantiation, or we're just not going to say those for now. We hold our marketing team accountable. They know that if they have a new claim, it needs to be approved by legal, and sometimes it means we have to just wait till we can get the substantiation there. We've worked hard to establish a culture of compliance. We want to keep all the laws, but we also are our marketers' best friends because we're helping them get the statements out that they want to make and do it in a compliant way.
Thanks, Craig. I think that was really helpful insight for someone in the trenches. You know, it's easy for me to be Dr. No. As Craig says, he doesn't want to fill that role, but I can just sit back outside of this and say, you can't do that, can't do this, shouldn't do that, shouldn't do this. Sometimes making Craig's job harder, but he does a great job with it. As mentioned at the beginning of the webinar, we need to take a brief moment to satisfy CLE requirements by delivering the following code word. All New York, New Jersey, Pennsylvania, and Kansas licensed attendees must type the code word January into the Q&A section on the right-hand side of your WebEx screen. Again, the code word is January. Please make sure to hit the send button so that it registers. Again, code word is January. We have 10 minutes left. There are a number of topics to cover. We're just going to cruise through it. Of course, any one of these topics could cover a full hour CLE, if not more. So obviously appreciate your attentiveness and your understanding that this is high-level training, and hoping that we'll have another opportunity at some point in the future to kind of get more into the weeds on it. Let's talk just very briefly about the Tcpa, Telephone Consumer Protection Act, and the TSR, the telemarketing sales rule, which are corresponding but different telemarketing laws. Tcpa generally, with few exceptions, the Tcpa prohibits auto-dialed calls or text messages or pre-recorded calls unless made with prior express consent of the called party. Text message advertising, Ringless voicemails are becoming very prevalent types of advertising and marketing and consumer communication or contact devices for companies. So it's important to know the scope that TCPA applies to that, as TCPA can give rise to substantial penalties and class action lawsuits. So there must be prior express written consent for telephonic communication that introduces any marketing or advertisement. There are restrictions on making auto-dialed calls to cell phones, which encompass both voice calls and texts, as well as ringless delivered voice messages. Such are considered a subset of calls or robocalls. You may rely on a consent for up to 18 months unless it's terminated earlier than that. The telemarketing sales rule generally is similar to the TCPA in that it requires telemarketers to make specific disclosures of material information, prohibits misrepresentation, sets limits on the times telemarketers may call consumers, prohibits calls to consumers who have asked not to be called, and sets payment restrictions for the sales of certain services on telephone. General requirements for calls: no profanity, misrepresentations of obscene language. You must disconnect unanswered calls after a certain time. Most importantly, you must scrub against national do not call every 30 days and not place any calls to any number listed on do not call unless one of the exceptions applies, such as written consent. Must not call outside the hours of 8 a.m. and 9 p.m. based on local time. You must not block your ID or spoof a local number. Protective measures are the same. Know the law. Know how the law applies to your business. Double opt-in for mobile consent is always really good evidence to have in the event that you're sued for placing texts or ringless voicemails or calls without consent. The law requires you to maintain an internal do not call list and also allows consumers to request an internal do not call policy within a reasonable time. The company has to produce that if requested in writing by a consumer. It's important to note that if you receive a request from a consumer for your internal do not call policy, you are going to be sued. In my experience, the only time a consumer ever asks for that is if they're trying to set you up. It requires third parties who are placing marketing, telephonic marketing on your behalf to scrub against your list. Of course, written policies and training and enforce your policies. Only use trusted sources for your leads. I have a lot of clients who engage in lead generation. I also have a lot of clients who buy leads and have found that when they're buying leads from sources that they haven't necessarily vetted or that they don't control as closely, we usually wind up in a situation where we're dealing with some sort of TCPA claim. For proper written consent, needs to be in writing, needs to identify the advertiser and all companies that will have access to the consumer's phone number. It's insufficient to simply say you give consent for company X and its affiliates to contact you. Affiliates is not open-ended. You must specifically identify the companies who will have access to the phone number. Make clear the type of communication that they'll receive. State that standard messaging fees may apply, include how the consumer can opt out, disclose the consumer is not required to provide consent as a condition of purchasing products or services, indicate some clear and affirmative agreement, and obtain the consumer's signature in some method that satisfies the e-Sign Act. Once you have written consent, maintain good records of that. As I said, scrub against do not call, understand other exceptions that apply. And also know that in certain states, there are state registration requirements unless there's some exception that applies. A list of the states that do have established registration requirements is identified on slide 41. Enforcement under the TCPA, consumer enforcement. This is a huge area for class action litigation. I'm currently defending 4 different class action lawsuits arising under TCPA at the moment. Attorney generals can enforce as well. Standard maximum fine is $500 per violation. That can be tripled if it's found that the defendant willfully or knowingly committed the violations. Typically in a class action, we're talking classes of tens, if not hundreds of thousands, sometimes millions of calls. So the damage numbers get very, very high very quickly. The TSR is enforced by the FTC. Because violations of the TSR are also violations of Section 5 of the Ftc Act, damages per call can reach $43,000 and change. Again, those penalties are staggering. The next law that we'll very briefly touch on is the CAN-SPAM Act, Controlling the Assault of Non-Solicited Pornography and Marketing Act. This is the federal email marketing law. Its name is a bit of a misnomer. It's not limited to pornography, and it's not limited to non-solicited marketing messages, as the title states. This is not an opt-in law, like the Tcpa is. So you're free to email anybody and everybody so long as you follow the rules. But any emails that you send, even solicited messages that don't follow the rules, could potentially subject you to civil penalties. In very general terms, the CAN-SPAM Act prohibits sending email with header information that is materially false or misleading. There are a number of ways that an email header can be considered false or misleading. On slide 46, you can check that out. There's also subject line, subject heading restrictions, as well as content requirements. Specifically with respect to content requirements, there has to be an opt-out notice and mechanism by which a party can opt out from receiving a message in the future. You have to identify the physical address of the sender. The sender is typically the advertiser, not the marketing affiliate. It's a very common area of misunderstanding and an easy way to violate the law. And then unless the recipient opted in, there needs to be a clear and conspicuous advertisement notice in the email message itself. Protective measures, know the law. We say that a lot. Know the law, know how it applies to your business. Bring compliance policies, enforce your policies, choose your affiliates wisely, and after due diligence. Of course, maintain internal email suppression lists. I dealt with a case a number of years ago, CAN-SPAM, where I represented an internet service provider as a plaintiff in a case involving a couple 100,000 fraudulent emails. And in that case, the defendant had evidence of a written compliance policy. They used a variety of off-the-shelf and customized services to ensure that they were aware of violations that were happening in their emails. But they never did anything to enforce their policy. They never took any enforcement action against any of the people, any of their affiliates who were violating the law. So we used that evidence in summary judgment to establish our burden of proof that the defendant procured the emails, as that's defined under the statute. So essentially turning their written compliance policy into evidence to support the plaintiff's case with a very successful outcome. Actions under the FTC can be brought by the FTC, by an internet service provider, attorneys general, and statutory damages can be $100 per header violation without a maximum. You can have a variety of header violations in a single email. So you're talking hundreds of thousands of emails at $100 a pop. The numbers add up quickly. Other violations are up to $25 per violation with $1 million cap. Lastly, and we're just about out of time, we'll take 2 minutes to do this, the Americans with Disability Act. This has given rise to a variety of consumer-based claims lately arising out of Section 302 of Title III for accessibility to websites which have been determined to be public accommodations. So the theory is that the website does not comply with WCAG standards, which is web accessibility standards, meaning the website cannot be viewed, accessed, utilized using screen reader technology, and therefore discriminates against the visually impaired. private parties can bring actions. This is an attorney's fees claim, basically, because there's no extinction or defined statutory damage. And courts have condoned cases by testers, people who aren't actual consumers, who aren't actually trying to buy products, but are simply testing websites to determine whether or not they're accessible to the visually impaired. I'll have Craig speak to this for 1 or 2 minutes, and then we will turn the time over to Chris Christie to tackle the second half of the presentation.
Thanks, Jordan. So at Purple, one thing I've worked on is making sure our web team is aware of this ADA rules. A lot of people don't know that this is out there, that you have to make sure your website is accessible to the blind. And so I've made sure that they are working on the WCAG standards and that they're testing it internally to make sure that it works. One of the problems we found internally is they can test it with the software they have, but it's not a real life test. So I've also hired an independent consultant. It's a man in Chicago who's actually blind. He has actual software that will read websites to him. So I regularly hire him to go through and audit our website, and he provides a report back on some things that we need to tweak, and I'll work with our team to make sure those get implemented quickly. We work hard to make sure that our website is completely compliant, and then I'm confident. We've had a few bounty hunter law firms send demand letters. I usually ignore those because I know that we're solid. If they have, and we've had some sue us, and I push back pretty hard because I know that our website's clean. I've actually had some of them pay me because they committed fraud and listing a defendant that wasn't real, and I brought that to their attention, and then they dismissed the case and go away. We've been lucky because it's hard to be 100% perfect, but we do really work hard at making sure we are compliant.
Thanks, Craig. I think that goes to the final protective measure, which is test, test, test. Websites are rapidly moving, rapidly changing to stay relevant, and every iteration needs to be tested to ensure that it's accessible to the visually impaired. With that, we appreciate your time and attention, and we will turn the time over to Chris to cover the second half of the presentation.
All right, this is Chris Christie. I don't have control of the slides yet, so
I made you the presenter, so you do.
all right. All right, my name is Chris Christie. I am the original Chris Christie, despite my namesake, who was born 3 years after me, having taken my name and been in the news more often than I am. I'm going to talk about legal ethics and technology, and a normal lawyer technology risk. An example of a normal technology risk comes from January 2020, and a group that became known as the Maze hackers attacked many law firms. There were firms that were identified in the press that were in South Dakota, Oregon, and Texas. The Maze hackers would steal information from the law firms and encrypt their data and require a ransom in order to allow the law firms to, again, use their data. One firm alone paid 200 Bitcoin ransom, 100 to delete the information that they had, and 100 to allow access to the information for the law firm to have information again. And at the time, a 200 Bitcoin ransom was about $900,000. And so any company or law firm or even individuals need to think about, are they next? Now, I'm going to talk about while working remotely, both protecting your company and how you operate your company. And it's going to be a lot of discussion about lawyers' technology risks while working remotely. Now, why are there risks? Your computer security at home is not as good. For example, people could possibly tap into your Wi-Fi when you're working from home. Just the idea of remote access creates security risks for a system. Lawyers or others may not be as careful at home as they would be if they were in the office. Lawyers have a duty to supervise others, and it is more difficult to do that when everyone is working remotely, or some people are working remotely. And knowing these increased risks, spammers are expected to increase their efforts to gain access to lawyers' information. While you're working remote, you have the same ethical duties as you would at any other time. You just have increased technology risks. And why is avoiding technology scams a legal ethics issue? Another way to ask the same question are, what are lawyers' ethical duties while working remotely? And in summary, you really have 3 ethical duties while working remotely. You have a duty to be competent, you have a duty to keep the client's information confidential, and you have a duty of supervision, both supervision of other lawyers and of staff. The confidentiality part is the part that's easiest to grasp hold of. And for an in-house lawyer, your client is the company that you're working for. All right. And so how do you manage these technology risks? I hope if you listen that you will learn and have some information that will be helpful to you and to your companies. I also have a handout, and the handout is very detailed, and the handout has citations and links in it. And so I encourage you, if you have other questions or want to learn more, to go to the handout and see how it might be able to help you. Now, legal ethics in technology. I'm going to talk about the ABA 2012 Model Rules Technology Amendments. I'm going to talk about lawyers' responsibility for others. I'm going to talk about ABA Formal Opinions 498, 495, 483, and 477R. And I'm also going to talk about a number of just practical considerations for lawyers about phishing emails, about ransomware attacks, and about computer security. All right, so the ABA Commission on Ethics 2020 proposed a number of amendments to the model rules dealing with technology. And in 2012, the ABA amended the model rules based on the Commission's technology recommendations. Lawyers, however, are not controlled or not under the model rules. Lawyers are all under a state's rules. All 50 states have a version of the model rules. 40 states have adopted all or most of the technology amendments. 10 states have not adopted those amendments. One of the states that is not is Alabama. Alabama is my home state. I work for Denton's in Birmingham, Alabama, and Alabama has not adopted the technology amendments. I believe that those amendments still apply. The ABA 2012 Model Rule Amendments highlight what lawyers should consider as to today's technology risks, and not understanding those technology risks could leave you being embarrassed or worse. Now, the 2012 Model Rule Amendments. There was an amendment to Model Rule 1.1, which Model Rule 1.1 is on competence, and Comment 6 was amended based on the different amendments that have been made to the model rules. It's now Comment 8, and to a phrase they added the language that's quoted on that includes including. So the before the lawyer, a lawyer should keep abreast of changes in the law and its practice. And Comment 6, now Comment 8, was amendment to add including the benefits and risks associated with relevant technology. Model Rule 1.6, dealing with confidentiality of information, had language added to it, had a new subsection C added. That new subsection C in the model rules and in most state rules now says a lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information regarding the representation of a client. I actually think that this subsection C that was added protects lawyers because adding the language reasonable makes clear that you're not a guarantor. I don't think that other lawyers would be considered a guarantor in states that have not adopted this amendment, but it is clear in states that have adopted the amendment to Model Rule 1.6, adding subsection C, that you're only required to make reasonable efforts to prevent the inadvertent or unauthorized disclosure of confidential information. In addition, Model Rule 1.6, what was old Comment 16 and is now Comment 18, defines or gives you examples of what reasonable efforts are. And there are 5 factors to consider as to whether or not the efforts were reasonable. So how sensitive was the information? In other words, is it something that is bank account information that somebody could use to gain financial benefits for themselves? Is it health information? The other factors are just how likelihood is the disclosure without safeguards, and how likely is someone want to get that information? How much do the safeguards cost? How much is it going to cost the lawyer to actually have those safeguards? And how difficult is it to implement the safeguards? Is the safeguards going to make the information basically unusable? And to what extent does the safeguard make representing your clients difficult? These factors highlight the trade-off and judgments that are required by lawyers to decide what efforts are reasonable, just like a lot of other things that we as lawyers are required to do. My favorite Dilbert comic, Mordak, the preventer of information services. Security is more important than usability. And then Mordak continues and says, in a perfect world, no one would be able to use anything. And then the employee is being told to complete the login procedure, stare directly at the sun. Continuing with the 2012 Model Rule amendments, Model Rule 1.6, what was Comment 17, and is now a Model Rule amended Comment 19. Whether a lawyer may be required to take additional steps in order to comply with other laws, such as state and federal laws that govern data privacy, is beyond the scope of these rules. All right, so what federal laws are we talking about? Primarily, we're talking about the Health Insurance Portability and Accountability Act, popularly known as HIPAA, and we're talking about GLB, the Graham-Leach-Bliley Act, and there could be other laws depending on what the particular industry a company or client may be in. And what state laws are we talking about? So in Alabama, we have the Alabama Data Breach Notification Act of 2018. So if there is a data breach, you are required in Alabama to notify those who might be impacted by that breach. And today, all 50 states have a version of a Data Breach Notification Act. And as an in-house lawyer, a particular difficulty you might have is figuring out which states you have to look at to comply with the act. So I can tell you that the Alabama Act has a safe harbor so that if you've complied with another state's data breach notifications, and that includes notifying people in Alabama, that you're covered. But and most states have that type of safe harbor. But if you have a data breach, you may have to consider 40 or 50 possibly states. Now, Model Rule amendments, Model Rule 1.4 dealing with communicating with clients. And there was an amendment to Comment 4. Old Comment 4 required lawyers promptly to return or acknowledge telephone calls. Amended Comment 4 requires a lawyer to promptly respond to or acknowledge client communications. That means emails or however else besides a telephone call your client may be communicating with you. You have an ethical duty to respond promptly. Model Rule 4.4b has to do with inadvertently sent confidential information. Notice is required when a lawyer finds documents that were inadvertently sent to the lawyer. The rule was amended to clarify that documents is not only paper, but also includes electronically stored information or emails. And inadvertently sent was defined in Comment 2 and was amended also to clarify when notice to the parties whose information was inadvertently sent have sent the information. Now, the ABA expressly avoided talking about a metadata issue. Now, metadata is data about data. And an easy example to explain is that when you get a Word document, you cannot see when you're looking at the Word document itself who has amended it usually. But there is metadata behind the Word document that can tell you when and who amended or changed and edited that document. Now, there are two different positions that states have taken. One position is that only with consent or court authority may a lawyer look at metadata. Most states have actually taken the position that no consent or court authority is required. Alabama was one of the first states to take a position on this, did it back in 2007, and Alabama Formal Opinion 2007-2 says that a lawyer must send documents with reasonable care. So you as the lawyer sending a document must exercise reasonable care, which probably means today removing the metadata. But it also requires lawyers who receive a native document not to mine the document for metadata. And if a lawyer knows that metadata was inadvertently sent, they must notify the party that sent the negative data, that metadata. So what does this mean? This means that if you're negotiating a contract, you're not to go and look at the Word document to see who amended it. So for example, an outside lawyer could send an amended settlement agreement, and the settlement agreement could show that the client actually made requests for certain changes. And a lawyer in most states is required not to look at the metadata to see who required the amendments. All right, now I'm going to talk about lawyers' duty to supervise others. Model Rule of Professional Conduct 5.1 has to do with responsibilities of a partner or supervisory lawyer. And a partner in a law firm is supposed to make sure that the other lawyers that he supervises act in conformance with the rules of professional conduct. And a lawyer having direct supervisory authority over another lawyer, that means that in the in-house context, if you supervise other lawyers, you have to have reasonable efforts to ensure that those other lawyers conform to the rules of professional conduct. Model Rule of Professional Conduct 5.3, which is a rule that all the states have adopted, deals with responsibilities regarding non-lawyer assistants. So with respect to a non-lawyer employed, retained by, or associated with a lawyer, so if you're an in-house lawyer and you've got staff that works for you, you have a duty to make sure that that you have reasonable assurance that the person's conduct is compatible with the professional obligations of the lawyer. In other words, you need to make sure that the legal assistants and staff that work with you also comply with the competency, confidentiality requirements that we've been discussing. Now, let's talk about ABA Formal Opinion 498, which was March 10th, 2021 opinion. This deals with virtual practice, and it defines virtual practice as being remote, technologically enabled law practice. And the formal opinion makes clear that if you follow the ethical rules, that the lawyers practicing virtually is permissible. It specifically refers to Rule 5.5, having to do with the unauthorized practice of law, and refers to ABA Formal Opinion 495. The opinion goes through and discusses how a lawyer practicing virtually needs to make sure that he complies with the competence, diligence, communications, and confidentiality requirements of the ethical rules, and also the rules 5.1 and 5.3 having to do with supervising other lawyers. Formal opinion, ABA Formal Opinion 495, which is from December 2020, deals with lawyers working remotely. And it makes clear and emphasizes that Model Rule 5.5a prohibits unauthorized practice of law, but a lawyer can work remotely in a different jurisdiction. If they do not do these things, if they do not establish an office or otherwise systemic presence that would lead people to believe that they are actually practicing in the other jurisdiction. So a New York lawyer cannot have, and who is not admitted in New Jersey, cannot have an office or other systemic presence in another jurisdiction that would make people believe that they are lawyers in that other jurisdiction. They're not to hold themselves out. They're not to have a presence or availability there that people would perceive them as holding themselves out as practicing in a jurisdiction in which they are not authorized. And if they're working remotely, they need to not actually provide legal services in that local jurisdiction unless they're otherwise authorized to do so. So in other words, you can get admitted pro hac vice and then you'd be admitted for that particular matter, but you're not to hold yourself out as authorized in a jurisdiction, in a state that you're not authorized. ABA Formal Opinion 483 from 2018 deals with the lawyer's obligations after an electronic data breach or a cyber attack, and recognizes that data breaches and cyber threats are a major professional responsibility for lawyers, and goes through the model rules on competence, confidentiality, supervising other lawyers, and supervising staff. ABA Formal Opinion 483 from 2018 also talks about what to do after a data breach or cyber attack, and it explains that a lawyer should follow the data breach plan developed before the breach. Part of that means that you're supposed to have a data breach plan. Also provides that a lawyer must monitor for a data breach. And if a monitored breach shows up, that the lawyer then has a duty to stop the breach and to restore the systems that he's using. He needs to determine reasonably what occurred and provide notice of the data breach to clients. And that notice must give sufficient information to the clients so they can make decisions about what other steps they need to take. ABA Formal Opinion 477R. The R just means that they revised the opinion because there were a bunch of typos in it, but from 2017, deals with securing communication of protected client information and reviews the 2012 Model Rules Technology Amendments. It talks about the duty to prevent inadvertent or unauthorized disclosures and reasonable efforts that are required of the safeguards dealing with the sensitivity, the likelihood, the cost, the difficulty, and the ease to use that the safeguards may impose. It also recognizes that special protections of data may be required by a lawyer because of either agreement or the law or the circumstances. All right, so if you want to go and find a place where the 2012 Model Rule Technology Amendments are summarized, ABA Formal Opinion 477 from 2017 is a good place to do that. All right, I'm going to shift gears. I'm going to start talking about practical cybersecurity considerations. I'm going to talk about avoiding phishing email scams. I'm going to talk about avoiding and responding to ransomware attacks. I'm going to talk about other computer security issues. These are going to include remote access risks, password fundamentals, mobile device security, Wi-Fi interception, and video conferencing. All right, so what does it mean? What do people mean when they say their computer's been hacked? Usually they mean that some user of the system or user of the computer allowed access. And the risks of being hacked or scammed are created by having remote access to a computer system. They're increased by responding to phishing and spoofing emails. Risks are increased by downloading software, either games or applications that have malware embedded in them, or by downloading malware by opening an email attachment, by opening an infected thumb drive, or by going to and opening questionable website links. Recognize that malware can record keystrokes, can encrypt data, can lock the system, as well as steal your data and require you to pay someone to get it back. All right, so here is an email to avoid, a phishing scam. This is an email that I actually personally received, and it appears to be from FedEx. And so if you will look at the email, you will see that it's talking about your FedEx.com email address. I actually don't have a FedEx.com email address. That was one clue that this was a phishing email, a scam email. Notice down here how the capitalization that is used and the grammar is not correct, probably indicating that someone who does not speak English as a first language has created this email. If you look down here where it says click here. If you will hover with your cursor, right? And that's what I'm doing right now. If you look at the screen, I'm taking my cursor and hovering over click here. If this was the live email, the URL or the uniform resource locator for the website that they're trying to get you to click to would appear. And when you did that, you could tell that it had nothing to do with FedEx. All right. So that's just different ways that you can tell that this was a scamming email. All right. Here's another email that this is a summary of an email that actually came from a lawsuit. And so PSG had a lawsuit, and the lawsuit started when the spear phishing email was sent. Spear phishing means that someone has gone to a lot of trouble to figure out what they need to do in a phishing email to get someone individual to respond. And so the controller for this company, and I've just used lead controller instead of the person's actual name, got an email that appeared to be from Josh Executive, but Josh, the executive, didn't know the email had been sent. And it was about an urgent fund transfer. In the email, and this is a summary of the email that was actually given, we have been working secretly on a key acquisition. Please wire the agreed 1.7 million as soon as possible. For wire transfer details, give full attention to attorney Mike Leach. Treat this matter with the utmost discretion and deal solely with Leach. All right, so that email was found by me as part of a lawsuit, PSG LLC versus Ironshore Indemnity Inc. Ironshore Indemnity Inc. was the cyber insurance for PSG LLC. So the scammers spearphished PSG's controller, and Leach shortly thereafter telephoned with wire instructions. Wells Fargo got those wire instructions and thought that they looked fishy and asked PSG to verify. So the controller then confirmed with Leach, the lawyer who had called him, who he did not already know, that yes, he should send the money. And because the controller confirmed with Wells Fargo, they released the hold on the $1.7 million. The $1.7 million was wired to the scammers 2 hours after the original email was sent. Now, PSG had a cyber insurance policy. That policy covered fraudulent instruction loss. And the insurance company denied the claim because they said it was not a direct loss, because Wells Fargo had questioned whether or not the $1.7 million should be really sent. Now, the trial court granted summary judgment in favor of PSG LLC, and the 11th Circuit affirmed that summary judgment for PSG. And now, how do you avoid being a caught fish? Right? How do you avoid the spear phishing scam like in the PSG case? Well, first, look for email red flags. You need to learn what these red flags are. You need to train others who work with you what these red flags are, and you need to test people who work with you to see if they actually respond appropriately when they get a phishing email by looking for these red flags. And what are these red flags? Purports to be from some authority. That authority could be the IRS, it could be a court, it could be a boss or executive. It urges, a red flag if the email urges a quick response. Another red flag if it insists on internal security. Don't tell others because this is secret. Another red flag is if it involves transfer of money. Anytime you get an email that involving transfer of money, red flag. You got to make sure that it is what it says it is. Another red flag is it requests using new payment instructions. In other words, to change how payments are being made to an existing vendor. American Tooling Center versus Travelers is another case. In this case, an imposter sent an email to the insured posing as the insured's vendor, and the imposter requested the insured to change the payment instructions, right? Send the payments to a different bank account. And so the insured paid the invoices into the imposter's account and instead of paying the vendor's invoices into the vendor's account. And so the district court ruled in this case that the scam was not computer fraud and that the insurance policy didn't cover the scam. The Sixth Circuit reversed and entered an over $500,000 judgment and instructed the district court to enter an over $5,000 judgment for the insured. Now recognize that the Fifth Circuit heard another case that almost had the exact same facts and reached the opposite result. And so actually, having read the two cases, my judgment is that the Sixth Circuit and the Fifth Circuit reached different results because the two insurance policies had different language, meaning you as an in-house lawyer or another lawyer reviewing a cyber insurance policy need to read the language and think carefully about what is and is not covered. Another matter to consider is if you get payment instructions that are changed, instructions to change payment instructions, you need to make sure that you verified with a trusted person that you need to change which bank account those payments are going to. All right, here's another scam email. And I want to point out some obvious errors, some problems that you will see in this email. And first, it says it's from American Express, but the email address that's being used is ourtime3@frontier.com. Frontier is a cable television provider who also provides email addresses. And when you first look at this email, it just would have said American Express. And I did something to it to make ourtime3frontier.com show up. So when I copied the email, you could see the email address that it was being sent from, which does not look like an American Express email address. And of course, the email is trying to make you feel comfortable, telling you that this is making sure that you are secure, and says kindly click on the link below to update and approve your payment. And if you put your cursor over the approve your payment now link, you will see that it is a URL, a uniform resource locator, email address, link address, a internet address that doesn't have anything to do with American Express. This is the second page of the same email that I received, and it tells me how to keep my account information carefully secret. And to learn more about email security or report a suspicious email, please visit us at americanexpress.com phishing. And I will tell you that when you hovered over that with a cursor, that also was not an American Express email address, nor was the customer care. So just recognize the phishing email here talked about security to make you feel like that you were secure responding to the email, and that was part of the fraud. All right, so avoid being a caught fish. This is other phishing scam red flags. Red flags that you need to learn to train those that you work with and to test those that you work with. And you have a suspicious email sender address. The email requests personal information, like account information. It has a generic or incorrect name in the greeting. In other words, it does not have your name in the greeting. The email requests clicking on a suspicious URL link. The email offers an reward if you open or click a link. If the email requests you to download a file, that's a red flag, a danger signal. And if the email asks for a login and password, you should not get an email that asks you for your login and password information. The UAB Criminal Justice Department, UAB being the University of Alabama at Birmingham, which is the local 20,000 student university here in Birmingham, Alabama, has a professor who researches these issues. And he did a seminar, and he was talking about a new junk email scams that people received from working remotely. He talked about the methods being the same. The email example he used, discussed, had Fox News logo on it. So some people trust Fox News. And so the scammer thought they could use that trust in order to get people to send them their account information or other private information. Other email scams that we've seen during the times where people are working remotely is selling virus cures, Intervectin, for example, or masks, selling fake donations to charities or promoting fake donations to charities. There have been fake emails that we're talking about SBA loans, Small Business Association loans, about getting $600 in unemployment benefits. about a $1,200 stimulus payment. And a lot of these emails require you to fill out the form, send your private information, and they may take you to a site that may give you malware. All right, let me talk about another ransomware attack that has been in the news for me locally and been the subject of a number of lawsuits. And DCH, which is the Druid City Hospitals system, actually owns 3 hospitals, one with 583 beds, which is a large hospital just about anywhere. Another with 204 beds, which is a medium-sized hospital, and then has a small hospital with 61 beds. In October 2019, they discovered that they had been attacked by someone who wanted a ransom. And they contacted law enforcement, they contacted their IT specialist, and they contacted a forensic consulting firm. And the hospital systems were shut down for weeks, for over 3 weeks. And they had to shift to where they were using paper medical records only. And they had, the hospitals had to transfer and divert patients to other hospitals. Eventually, the hospital system paid the attacker a ransom for a decryption key. Another problem they had is a number of hospital patients were getting telephone calls, falsely claiming to be calls from DCH. So the hackers, the attackers, had gathered telephone information, telephone numbers, and names and diagnoses for attackers, and were using those to try to get the patients to also send them money. There were 3 different class actions that were filed all about the same time, shortly after the hack. One of these was Daniels against DCH Healthcare System, which was filed in the Northern District of Alabama. It alleged negligence, breach of contract, breach of fiduciary duty claims. It's a class action alleging class damages and equitable relief. The allegations include that patients had to forego medical care, had to seek alternative care, which was further away, and that their identities were at risk. So the 3 class actions that were filed were all dismissed about 120 days after they were filed. Now, let me go over avoiding ransomware attacks. Let me first talk about some don'ts. Don't open risky emails or attachments. Don't click on risky URL links. Don't download games or non-work apps. Don't open risky thumb drives or CDs. Don't visit suspicious or fake websites. Don't respond to urgent requests, email requests, any kind of request. Don't trust telephone caller ID. Somebody can spoof a telephone number and call you, and you may think that it's a number that you recognize, but it may not be. People can spoof telephone numbers. And don't. And this is one that I'll say never. I usually say never, but never reply to an email or a telephone call with your password. Here's some do's for avoiding ransomware attacks. Block unsafe, suspicious, or fake websites. In other words, don't allow employees at your company to access unsafe, suspicious, or fake websites. Check suspicious URL addresses. Install antivirus or security software. Update all types of software. If your software can't be updated, replace it, because there are leaks that can occur into your computer systems through software, and they need to be updated to avoid that. Separate work and personal computer use. Backup files in remote, unconnected places, all right? And recognize that the scammers now have gotten wise that people have backups. And so you need to have backups that extend back months. In other words, you may have a ransomware attack, learn about the attack, and then you may go to your backup. And your backup that's only a week old or a day old, for example, will also have the same problems in it and allow the attackers to have access to that. And so you have to back up further back than when the attackers first accessed your system. And so you need to have backups that go back months. And always just use common sense to try to avoid attacks. All right, how do you respond to a ransomware attack? Well, you implement your cybersecurity response plan. I guess the first step in implementing a cybersecurity response plan is to have one, right? And so what type of elements should be in your cybersecurity response plan? One is who you're going to call with law enforcement, federal or state law enforcement contacts. What individuals are going to be trained to respond. All right, this is both individuals at your with your company, but also what individuals outside your company. And then, of course, what consultants are you going to call when you have a cybersecurity ransomware attack? What lawyer are you going to call? Are you going to call your insurer? Right? Other things that need to be done is to assess what happened, what damages occurred, and then to use the backup data and to make sure that the backup data you're using has not also been infected, that you go far enough back where you're not using infected backup data. Your cybersecurity response plan needs to think about, do you communicate with clients or customers or others? Do you issue a press release? Do you put a notice on your website? Do you put notices on social media? DCH Health Systems did all three of these. They issued a press release, they put information out on their website, and they put information on their social media so that people would know that there had been an attack and could protect themselves. Actually taking those actions was part of what could allow a company that has had a ransomware attack to settle a case or to avoid class actions. Do you negotiate with the attackers? This is a very difficult question. Originally, the FBI said you did negotiate, you did not negotiate with your attackers, and they changed it saying that you did, and then they changed it back to saying you didn't. Recognize that in August 2021, Treasury Department came out with a notice that negotiating and paying ransomware could itself be a crime. You could be funding criminal activity. So it requires a lot of thought and judgment about whether or not to do that. All right, what about ransomware resources? If you're practicing virtually, what resources do you have available to you other than my CLE handout? And so the Cybersecurity and Infrastructure Security Agency, an agency of the federal government, has a website and a blog. And that blog has news and links and how do I respond. It has a lot of really good information. They can also give you a ransomware guide. And this ransomware guide is a publication that they have with two parts. And part one is the ransomware prevention best practices. And part two is the ransomware checklist. The United States Secret Service, yes, the Secret Service, the same one that protects the president, also has a website with similar resources available to you. And so the cybersecurity CISA's website seems to be more thorough and have more information, but the United States Secret Service has another one that you can go to. All right, let's talk about remote access risks. We're talking about computer system security. Remote access to your firm's computer or to your company's computer system creates risks. Allowing people to dial in, to get on their Wi-Fi, or any other way to get into your security system creates risks. And how do you manage those risks, reduce the risks? Recognize strong passwords can stop brute strength attacks. You can have a strong enough password today to where a brute strength attack basically cannot find it. And so usually what you have is people either through malware or through having phished somebody or some other way gotten a password. And that's usually how people get access to computer systems. Multi-factor authentication slows even stolen password attacks. And what do I mean by multi-factor authentication? It could be a biometric like a thumbprint, an eye print. It could be something like a telephone call. All right, so what does my law firm do? My law firm requires complicated passwords. And in addition, once you enter that password, you get a telephone call. And you have to approve access to the law firm's system through that telephone call. proving that telephone call requires you having not only access to the phone, but having a PIN that you can get into the phone. And then once you get the approval, you have to enter another PIN. So you see that you've got multiple levels of protection to get into my law firm's system, computer system. And so your company can come up with whatever its multi-factor authentication is, but you need to have at least two-factor authentication. All right. There was another health system here in Alabama that, well, actually it's a larger health system than just the state of Alabama. And there was a multi-district litigation that was consolidated in 2021 here in Alabama, and it was resolved in large part because of the multi-factor authentication that health system had already adopted, and therefore limited the access that the ransomware attackers were able to have. Now recognize that adopting these types of systems probably is going to require you to have a system. Have a consultant for your system. So remote access risks may warrant hiring a consultant. You need to safeguard your servers, your desktops, your laptops, your tablets. You need to be able to safeguard your smartphones, your copiers, your scanners, the Internet of Things. All right, so IoT, your Internet of Things, is your lights and your copier, your thermostats. All of those, some can provide entrance into the computer system at a building, at a company. Staff changes. If you have changes in staff, you need to make sure that staff person's user account is ended, that whatever user accounts they had access to are changed, password changes. I have a lot more information on this aspect in the handout. All right, let's talk about password fundamentals. You should avoid weak passwords. And what is a weak password? A weak password is any password that someone can guess. You'd be surprised, password is the 4th most common password in the United States. And what is the most common password? 1, 2, 3, 4, 5, 6. And the second most common password is the slightly more inventive 1, 2, 3, 4, 5, 6, 7, 8, 9. All right. So don't use a password that someone can guess. Someone could look you up and figure out something about you. Don't use your own name as a password, for example. All right. A good password has at least 8 and probably has more characters. My law firm requires more than 8 characters. And some people use even more than the minimum required. Include capitals, include numbers, and include symbols. You know, by symbols, I mean things like a $, pound sign. You know, those are the kind of things that you would need to have. Consider passphrases. Consider using leet speak. What is leet speak? Leet speak is turning a common word into something that's not common by using symbols or numbers. So you could turn the word leet speak into a good password by using L33T $P3AK. But notice that you've used leet speak to create something that you can remember, but is almost impossible to guess. Consider passphrases. So for example, using leet speak again, but use 5, 6, 7, 8 space, main space, street, substituting in the @ symbol for the A and the street sign for the street. All right, so that's a long enough, that's a 16-letter password that brute strength probably cannot break, but you could possibly break it if you allow someone to have it, or if you save it in a way. So how do you use care with saving your passwords? Well, don't put it anywhere close to your computer. Literally, we did an audit at a client's business, and they had people who had had their Post-it notes under their mouse pad with their passwords on it. And you don't want to put all of the passwords in a document. That document could be vulnerable in and of itself. There are different judgments about whether or not using some of these services that save all your passwords is good, because if someone breaks into your service, they got all your passwords. So it depends on how confident you are that the service saving all your passwords is actually secure. Mobile devices. What do we need to know about mobile devices? And by mobile devices, I mean laptops, tablets, smartphones. You need to have a PIN at least 6 digits or stronger. Recognize that if you have a phone that does not have a PIN, that someone can take your phone and swap the SIM, and I'll explain some other time to people what that is, but basically every phone has a SIM number. Somebody can steal your SIM number and then have access to all the things on your phone. And if you don't have a PIN or a password, then your phone is very vulnerable from somebody who works at a phone company accessing selling your SIM password or SIM swapping your phone. You need to consider multi-factor authentication for your laptop, right? Two-factor identification at least. You need to consider having remote wiping. If you have an Apple product, Apple can wipe your phone for you. If you work at a company or a firm, everybody who has access to the firm computer system or the company computer system needs to have you need to have the ability to remotely wipe their laptops or tablets or smartphones if they lose them. You need to consider having wiping after 10 failed password attempts. You need to use mobile device management. Mobile device management not only provides remote wiping, but also controls what software can be added onto a company's on tablets or laptops or smartphones that have access to a company's computer system. You might consider limiting the confidential information on a device. So my devices, my smartphone, for example, does not have any emails or other information on it that's more than 2 weeks old. I automatically make that information not accessible on my cell phone. Wi-Fi. Is Wi-Fi secure? And actually, Wi-Fi is not always secure. There is such a thing as Wi-Fi packet sniffing software. And so if you're at a cafe or a hotel or a doctor's office and you're using the Wi-Fi there, someone can get packet analyzer software. It's available. You can just Google Wireshark and you can buy packet analyzer software. And with that, you can capture emails or whatever is being sent from a laptop to the router that's being used to then send that into the internet. So if you're using unencrypted email, someone can capture that email with a packet analyzer software and read the email like it was plain text. If you do have it encrypted, it's going to be garbage. All right. So you need to use an email system. If you're going to ever use Wi-Fi somewhere, you need to use an email program that encrypts the email. Microsoft Exchange encrypts the email. And how can you tell? Well, if the website for the URL up there at the top when you're looking has HTTPS, that S stands for secure, which means that email coming from an HTTPS site is going to be encrypted email. Even safer would be to use a VPN connection. That is like sending your emails or other information through a tunnel that nobody else has access to. If you're going to be using email to communicate with your client or your company, you need to advise the client that that they need to make sure that their emails are secure. So, for example, if you have a company that has a number of officers, and a couple of those officers, use their email at a place that's subject to a Wireshark packet analyzer software, at a cafe, at Starbucks, that they don't use Gmail, right? There is secure Gmail, but most Gmail is not secure. And so if you've got somebody sending you email on a Gmail account, you need to advise the client that that may not be secure, and you need to seek their consent before you send them attorney-client communications. Is Zoom or other video conferencing, WebEx, like we're using right now, is that secure? And so recognize there was a congressperson who objected to having congressional Zoom meetings and wanted to ban that. And originally, 2 years ago, Zoom did not have end-to-end encryption. It did have some software that originated from China, but Zoom does not use servers from China in the United States. Recognize originally there were some Zoom meetings that were bombed, and most of those turned out to be waiting room mistakes. But the Zoom bombing did, for example, for some schools, put obscene images up or racist messages. Free Zoom originally had no passwords and had no waiting rooms. And Zoom has addressed those issues. If you're going to use Zoom software or WebEx or some other similar software, I recommend that you use the paid version of that because it will be safer. But recognize that Zoom now is probably safer than using your cell phone or unencrypted email programs. Now, video conferencing. The Alabama Administrative Office of Courts did an investigation, hired a consultant, and the courts now use Zoom Professional, and it's helpful for a private setting. It requires a PIN to get into the meetings. And I would suggest that using Zoom Professional for everybody ought to be safe as long as you use the same safeguards. The possibility of third parties, for example, Facebook capturing metadata when you're using Zoom has been removed, and that's no longer a problem. The Pennsylvania Bar came out with a very helpful formal opinion in 2020 that talks about working remotely, has 14 pages and goes over the same rules we've been talking about in terms of competence, confidentiality, and supervision, provides 15 best practices. The element that the Pennsylvania Bar formal opinion added that I had not thought of before I read it was to avoid Alexa. So if you have some kind of software in your home or in your office that listens to you and does things, then you don't need to be using that Alexa or other similar software when you're dealing with confidential information. So if you're a lawyer working, don't have Alexa turned on where you're working. And then also the other thing that the Pennsylvania Bar emphasized was to have video conferencing, private password, and guard links. All right, I've got a question from somebody. They're asking me if I'm familiar with a group sometimes referred as Ransomware Hunting Team. And I have not heard of this particular ransomware hunting team, but I will warn you, there are some ransomware hunting teams who tell you that they will decrypt your information, but what they actually do is they negotiate with the attackers and then basically use that negotiation without telling you that's what they're doing. So if you are getting to a ransomware consultant of some type, you need to vet them pretty carefully.
Chris, I'm sorry to interrupt here. We're just about to the end of the time, so would you mind reading the CLE code word out now?
Well, yes, it's the word protect. I started 5 minutes late, so I was going to go a couple minutes extra just to make sure everybody had their hour for ethics. But here it is. The CLE code word is protect. As mentioned at the beginning of the webinar, we need to take a brief moment to satisfy CLE requirements by delivering the code word. All New York, New Jersey, Pennsylvania, and Kansas licensed attendees must type the code word into the Q&A section on the right hand of your WebEx screen. Please make sure to hit the send button so that it registers in case you missed it the first time. All right, so let me tell you, I have one more thing I want to talk about, and that is cybersecurity insurance. And should your company have cybersecurity insurance? And it depends. It could reduce the risk loss that you have. They could provide helpful audits. It provides a predictable expense, but there are some trade-offs. It is very expensive. A client I know paid in 7 figures for an annual premium for cybersecurity insurance. I have heard of people paying 8 figures annual premiums, and there are a lot of losses that may not be covered. You need to look at a cybersecurity insurance policy very carefully and see what exclusions it has and what may happen. The person who could not hear the CLE word, it was protect, Protect. All right. Recognize too that if you have cybersecurity insurance, you could lose negotiation control with the attackers. You could have delays in your data return. The ransomware attackers may have also had access to information that gave them the limits of your cybersecurity insurance and your deductible. And if those can be discovered through the access to your system, then they may also use that to negotiate better. All right. I have some hypotheticals that I'm not going to go over for time. So in conclusion, if you're working remotely, you've still got the same ethical duties to be competent, to guard confidentiality and supervise those that you're working with. If you're working remotely, you've got the same ethical duties and increased technology risks. And I hope you've learned how to manage those risks by listening. And again, I refer you to the handout. It's got a lot more information. Thank you again for participating in today's CLE. If anyone wants, they may ask. I'm glad to repeat this for any bar that wants to. I've done a 20-minute and a 30-minute version of this for clients. And if you've got a client, I'm glad to do that for you too. If you're a company and you're an in-house lawyer and you want me to do it for yours, contact your Denton's contact, and I'm glad to participate with them and to provide a 20-minute or 30-minute version of this for employees of your company. In approximately 15 days, you'll receive an email with a link to your CLE certificate. Your webinar login details will be there, and it'll be used to process these certificates. No additional steps are required. As a reminder, the code word requirement is only if you are seeking credit in New York, New Jersey, Pennsylvania, or Kansas. And have a great day.